Welcome to Illinois Law. This is a service of the Illinois State Bar Association, and I'm your host, John Theis. In today's program, we're going to talk about alternatives to going to court, specifically in the area of mediation, arbitration, collaboration, and other ways of avoiding what can also be often be time-consuming and expensive litigation. And we put together a very distinguished panel of practitioners who are well-versed in this area, and I'd like to introduce them at this time. First, Sandra Crawford is an attorney, a mediator, and a collaborative practitioner. She is a graduate of John Marshall Law School, and she is the chair of the Illinois State Bar Association Women in Law Committee. She has her own professional training company, Trainers for the Advancement of Collaborative Process, and she's well-versed in collaborative practice, mediation, arbitration, and litigation. Our second panelist is Assata Peterson, who is an attorney with Shellis Law Firm and the Shellis Law Firm in Chicago, where she is involved with litigation, civil litigation, in the areas of insurance defense, contract disputes, and other matters. She's a former law clerk with the Illinois Appellate Court First District, and was honored as the 2010 Arbitrator of the Year by the Chicago Better Business Bureau. She is a graduate of George Washington University Law School and is licensed in Illinois and New York. And our third panelist is Teresa Frisbie. Teresa is the director of the Dispute Resolution Program at Loyola University School of Law and has mediated and arbitrated hundreds of cases. She is a graduate of Loyola University's Law School in 1986. Thank you very much for joining us, and welcome to all of you. Well, I guess the first question is, lawyers usually are pictured often on TV and in other media as people who go to court and try cases. What's this mediation and arbitration stuff, and who wants to tell us what these words mean and what it means and what the differences are among them? Teresa?
Well, I guess I can start. Mediation is really a facilitated negotiation between two parties. So you have a neutral third party serving as the mediator, helping the parties come to a voluntary agreement. And it's really the parties coming up with their own agreement. That is quite different from arbitration, which is sometimes described as hiring a private judge. So it's one arbitrator, or could be three arbitrators, and they are making a decision that it's called an award that they give to the parties, and that award can then be enforced in a court. So those are two very different processes, and they are outside of a court process.
Okay. And we also used another word, collaborative process. Maybe, Sandra, could you tell us what that means and how that fits into those other concepts that we discussed?
Yeah. Collaboration is a non-court process in which the parties are represented by two attorneys who are specially trained in the collaborative law method, and those attorneys join together with the parties at the outset to sign something called a participation agreement. And part of the participation agreement is the attorney's commitment not to take the case to litigation. It's much similar to the European system, the British system, where you have barristers and solicitors. The barristers are the litigators, the solicitors are the negotiators. So in a collaborative process, I'm an attorney representing a client, but at the outset I agree, along with my counterpart counsel for the other party, not to take the case to litigation if we can't resolve it at the table. And we do use many of the skills. Most of the collaborative community here in Chicago is mediation trained, so you use the skills, the mediation skills that you've learned at the table with the parties. It's also an interdisciplinary process where you bring in not only legal professionals but mental health professionals and financial professionals to support the parties, kind of a network around the parties. The predominant model is in family law, but there are applications in other difficulties where you need a sustained relationship after the particular legal problem is solved.
Assata Peterson, you are involved in litigation as well as in arbitration. Maybe you could explain what the advantages are and why some cases go to litigation and some cases are arbitrated.
Certainly. One of the greatest advantages of any alternative dispute resolution process, whether it's mediation, arbitration, or collaboration, is that parties really get an opportunity to have a bit of a say in how the process will proceed. It's usually less formal. You have less, the court rules and the structure. It can be rigid for parties. Oftentimes parties feel like they haven't been completely heard or haven't really had an opportunity to voice their concern as they see fit. In an arbitration process, what you get is the opportunity to sometimes determine what the rules will be, determine if there is going to be and how much exchange of information there will be, and you also get an opportunity in some instances to express yourself a little bit more than you may in court. And if you're in mediation, you even perhaps get more of that expression of airing out how you feel and really getting to concerns that you may not be able to get to in a court process. Another really great advantage is it can be less time consuming. In Cook County, the docket is extremely full, as I'm sure is the rest of the state of Illinois, and courts are really looking for a way to move along cases and really get parties to a resolution without being boggled in the system for years. So what arbitration, mediation, and collaboration can do is really shorten that process so that people can get to some type of resolution without spending all their time and all their energy and all their monies in the court process.
Yeah, that was the other another question as you were talking about the time. Obviously, litigation can be more expensive. Is that been your experience as well for all of you?
Yes. Although I would add that there is something that has developed in arbitration in the past few decades where it has become more like litigation. For example, seeking pretrial discovery, which is when you try to get information from the other side, whether it's taking a deposition or getting documents or whatever, that has kind of become part of arbitration. And recently there are some institutions that are working very hard on some reforms to have arbitration be more like the streamlined process it was originally intended to be. So it's not a mirror of litigation without appeal. It's actually a more streamlined process.
Absolutely, and parties can actually agree to what they want in an arbitration process. They can agree amongst themselves, attorneys, if you're represented by counsel, can agree, hey, we're only going to exchange documents on one issue, or we're only going to allow exchange of information, what's called discovery, for a 1-month period, or however they choose to set it out. They can also agree on how many people will hear their case, whether it's a panel of 1, a panel of 3. There's really a lot more control. So while the cost can get high, there is more of an opportunity to control it when you're in another forum other than court.
Are there types of disputes that lend themselves more easily to mediation? For example, you mentioned domestic relations, divorce situation. Are there others that lend themselves more easily to that sort of thing?
I think any time that you have potential for a continuing relationship, whether it's a partnership or it's a family fighting about an estate, clearly divorce law is an area. Any time that these parties may have some sort of relationship that they can salvage and then benefit from, mediation is a good thing to consider, because that is something that you can maybe fix that you're very unlikely to fix in the litigation process.
And likewise in collaboration. I think the unifying factor between all of these models is that they're client-driven process. They don't, except for arbitration, they don't rely on a third-party fact finder, a third-party decision maker. The clients have more control, more decision making about what they're submitting, what issues they're going to submit, and how they're going to resolve their problems. And that gives the public a lot of control over costs and timing. And at least in collaboration, we talk about that from the outset. How much, what's your budget for this process? How much do you want to spend? How much time do you want to spend resolving the problem? The
individuals who take on these roles as a mediator, arbitrator, or collaborate in the collaboration process, what kind of is it? How does someone get to be that? Is there training involved? Is there an education process?
Well, for example, at Loyola, that is part of what you learn in law school now. So you're learning how to be a great trial lawyer, but also to get this other set of skills. So for negotiation or mediation or the collaborative process, you're learning how to do interest-based problem solving. And arbitration, you can take a class solely devoted to arbitration, or a class that is alternative dispute resolution, where you study each of these things. and you learn, oh, the differences, for example, the various arbitration institutions, what kinds of rules do they have, you know, what might be best for my client in a certain situation. So it is very much something that you can learn in law school. There are also institutions that provide training in these things.
And specifically for collaborative, there is a specialized 2-day basic training to bring all the professionals, the legal professionals, the mental health professionals, and the financial professionals on par with one another in terms of what that process is, because it's a very different process, because in a way you're not relying on the myriad of court rules and all of the rules that are in place in a more structured process.
Is there a certification process for these individuals as well?
There's a training, yes. At the end of the training, you get handed a certificate, but it's just another credential, and you need that credential to be effective and to know that.
But for example, it's not like having your law license in the state of Illinois and then you get a separate mediator's license. People from different fields come to be, for example, mediators. Maybe somebody that's a psychologist, a lot of lawyers, it's a variety. Social workers.
Well, after we take a break here, one of the things that I'd like to talk about is how the process works, and at what point of the process that the parties either agree on or are presented with the opportunity of going to one of these three. And then maybe we could even talk about which is more appropriate in any particular area of law. But thank you very much. We'll be back in a few moments to discuss the alternative dispute resolution process, mediation, arbitration. This is Illinois Law. This is a service of the Illinois State Bar Association, and I'm John Theis.
Bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan.
What about incorporating?
And insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never!
Over and over.
Come on! It's our leave me alone! Shut up! Out!
Time and again.
No! Drive me nuts! Shut up! You're the dumbest
Generation after generation.
I hate you! I hate you too!
Isn't it time we stop the cycle? Now.
I hate you!
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to Illinois Law. This is a service of the Illinois State Bar Association, and I'm your host, John Theis. Today we're talking about alternatives to going to court and to having expensive and time-consuming litigation. And we put together a panel of three people who are very familiar and practice in this area. Sandra Crawford, Assata Peterson, and Teresa Frisbie, and thank you very much to all of you for joining us here. Before the break, we were talking about mediation and arbitration and collaborative practice. Tell us, at what point in the process are these options presented to people as opposed to going to court and litigating it? Anyone have any suggestions as to when the people are presented with this option?
Sure. At any point in the process, it really depends. It can be at the beginning point or even pre-dispute where there's a contract. Oftentimes, contracts will dictate how to resolve a dispute. And most people will see this in cell phone contracts, automobile contracts. If someone comes in, builds a new porch for you, it may be in that contract. There's a growing awareness of alternatives, and oftentimes mediation and arbitration may be placed in a contract so that parties know what to do if a dispute arises. However, if you choose to go to court, you may be sent to arbitration or mediation by order of the court. The court may say this case is appropriate for mediation or for arbitration, or give the parties that option. But it's never too late or too early to decide which method you're going to choose. And oftentimes, litigants will find that it may end up being the best option for them after all. After, fussing for some time, they may see that there's a better way to handle things.
But I would point out that mediation is voluntary. So the court may send you to go through the mediation process, but whether you reach a resolution is voluntary. So that's a little different
Correct.
than arbitration.
And collaboration is a little bit different because it really is when the clients start to have the problem, the issue starts to come to the fore. And the example is in family law, when people are starting to think about what processes they're going to use. But sometimes there is cases filed and then they're dismissed and the parties come into a collaborative process. But it's about choices. As I said, all of these processes are client-driven, and we want the public to know that they do have choices and to ask, what's the best process for me? Litigation, arbitration, mediation, collaboration, or a combination of some of those. There's some models. There's a model called MediCollab out of California where they combine collaboration and some mediation. So there's a lot of different choices in terms of the process that parties choose, and the public should be empowered to know to ask about that before they make a decision.
Does it matter whether, do the lawyers present these possibilities to people? So if you already have hired a lawyer, it doesn't necessarily mean that this is now going to court and is going to be litigated in court.
Well, that's right, because the lawyers have actually an ethical duty to explore alternatives with their clients. And then they can advise their clients on whether they think this is a case that maybe we could try to mediate right at the beginning, or perhaps they feel strongly that a certain amount of discovery needs to take place, information gathering, as we talked about before mediation, for example, would be appropriate.
In my daily practice, when I'm dealing with clients, as a matter of routine, we're counseling them on whether there's going to be an arbitration or the possibility of a mediation, just because it's so prevalent now in our method of resolving disputes that it's only proper to let them know that these are the ways that we can go, these are options, and kind of let them know what the process is about and what they can expect, and let them decide or let them see how these things work out, and there could be a better way for them.
Part of it is the expense. Litigation is extremely expensive. And in recent years, with the explosion of electronic discovery, that just makes it even more expensive. And what I mean by that is all the different ways that people communicate now. I mean, you think about it, 100 years ago, if you had a contract dispute, you had the contract, you had a couple of letters that were exchanged, maybe some testimony about a conversation or two, and all of that would come out in a trial, and then a decision would be made. Well, now, just the email alone, you put together search terms, and somebody has to search the email, and we're all sending messages to each other in a million different ways. It's very expensive to get all that information. So that makes these alternative processes more attractive.
Yeah, and what you described, I think, pretty well here, the discovery process. Basically what that means is that when a case is filed, or sometimes at some point in the process, the lawyers are spending the time, or investigators, whoever it is working on behalf of the lawyer, spending the time going through all of that, and all of that takes time. And you're saying that in general, mediation or arbitration can cut a lot of that out of the process, and therefore the expense.
Yes, and you could maybe narrow the areas where you do need to get information from each other. Some of it could be exchanged informally within the mediation process or the arbitration process, which is really important to point out is confidential, which is very different from court. Some of that could be exchanged informally, and then maybe there could be a decision, well, we all agree that we need to get more information about this one thing to help us come to a settlement or whatever the arbitration award needs to be.
Explain that a little bit, the confidentiality, because I'm not sure I understand. What you're saying is that unlike court, where everything is done in open court and documents are, unless there's some sort of order to the contrary, people can find out what is submitted. These are they all confidential?
It's not. Arbitration is not always a confidential process, but it typically is, and usually that is governed by the rules that are governing the arbitration, which either the parties can craft themselves, but typically there's an institution with rules that everybody's using. For mediation, it's almost always confidential, and there's two kinds of confidentiality. The first is that the process is confidential vis-a-vis the whole world. So the people in the mediation, things that are said stay in the mediation. Somebody can't be forced to testify about what somebody else said in the mediation. And then the other part of it is when the mediator gets with each side individually and talks to one party and their attorney, they will keep things confidential that that side wants kept confidential from the other side.
And is that something that typically happens?
It's the same in collaboration. It is a confidential process, and also there's a commitment as part of what I call the participation agreement that is signed by the parties and the attorneys from the outset to have full and fair and frank disclosure and honest and disclosure and act with integrity and keep everything confidential and not let the attorneys be drawn into the conflict. They can't go to court to testify on behalf of either one of the parties, nor can the other professionals, the interdisciplinary team we call it, of mental health professionals or financial professionals that are brought on board to support the client. So there's a lot of attractiveness to this process, especially in things that can get very contested, like family law disputes or probate disputes, or partnerships, business partnerships, where you might not want the dispute within the partnership to, you don't
want your competitor to hear all that.
Yeah, they might take some market advantage, and the model is growing within the non-family area very rapidly because of those considerations.
Does it happen, Assata, where people go through one of these processes, but it fails and they end up in litigation anyway?
Sometimes it does. I want to say the overwhelming majority of mediations are successful. And when I say successful, it depends on what you're there for. You may be mediating or only handling a certain number of issues, or maybe one or two issues. But oftentimes people are able to resolve things as they agree. In an arbitration context, when parties receive an award from the arbitrator, it depends on the forum. In some forums, for example, the Circuit Court of Cook County, there's the ability to reject the award and say you want to go to court and you want to go to trial. However, in other forums, whether it's a private institution or an organization, disputing an arbitrator award is very difficult. So not agreeing, the thing about being in a dispute is someone's not going to agree all the time. And what you think about is the toll, again, which is what are the costs. And oftentimes when we talk about the costs of litigating, we forget about the costs to the client. The client is usually taking time off of work. It's an emotional toll. There's coming...
It's not, when you say cost, then you're not just including the dollars and cents. You're talking about the emotional toll of going through this process.
Emotional toll, and depending on your job. It could be dollar and cents if you have to take off and you perhaps have an employer who's not that happy about it or not that receptive to this type of thing. So there is a greater cost that clients have to think about. So when you talk about disagreeing with an award, oftentimes at that point the costs really start to come into play. And litigating or being in a dispute for a while, most people can't do that. At some point they want to let things go, even if they are upset.
And something else to point out, for example, if you've mediated a case, you've been there all day, and you don't reach resolution on every single issue, I find all the time that a lot of progress was made because a lot of information was exchanged, everybody's focused on the case, they really know the case a lot better, and it's just a matter of a couple of weeks, maybe a follow-up session or even just some phone calls, and the case settles. So it's not just a complete waste of time, but yeah, it's not for every instance.
Right. And I don't know if you can answer this, but do you think that parties come away from a process, an alternative process like this, with any greater level of satisfaction than they would if it went to litigation?
Absolutely.
I've been thinking about that. Yeah.
Okay.
Yeah, I think that's unanimous because they get to craft their own process, and usually the agreements that they make are much more sustainable because they've adopted those agreements. They understand them. There's a lot more education that goes on in these processes about their ability to choose and not leave it to the man and the woman in the black robe at the courthouse who may have 60 other cases on their call that day.
And that is a really important point, because one of the big advantages is the creativity that you are allowed by, for example, mediation. So let's say you have two partners fighting. The traditional litigation path, somebody locks out the other one, they run into court to get a temporary restraining order. That process is so accelerated, the legal bills are so high so quickly that everybody can't pay the lawyers anymore, so they come in and they come up with some monetary settlement, and that's the settlement. Now, if you did it in a mediation, you start talking about why did this develop in this way, and you may end up still doing business together. I've mediated cases like that where the partners went on together but in a different way.
Well, thank you very much. I hope this has been helpful. It certainly educated me as to a lot of what this process is involved, and I want to thank our very distinguished panel here, Sandra Crawford, Assata Peterson, and Teresa Frisbie, all in the area of arbitration, mediation, collaboration. This is Illinois law. This is a service of the Illinois State Bar Association, and I'm your host, John Theis. Thank you very much for joining me.